Hello everyone, Hashi Richards back with another video. So if you have been following along, you will know that I am going over the top estate planning mistakes to avoid, right? We don't want to do these things while we're planning our estate, right? And planning our will and trust and all the ancillary documents. So these are things we want to avoid. And so today we're going to do mistake number 5. And mistake number 5 is not discussing your plan with family or friends. So what do I mean by that? Do I mean you sit down with everyone that you've named as a beneficiary, letting them know what your plan is and what you intend to do with your assets after you pass? Well, I mean, if you have, that type of relationship with your family and the people you are planning on leaving assets to, it might not be a bad idea. That way there's no expectations, people being disappointed, and people sort of know the game plan, so to speak, right? Now, I'm not advising that you do that. Obviously, anything that I say here is not direct legal advice to you, right? It's just general statements that I'm making. But if you so choose to do that, you feel like you have that type of relationship, then go ahead, right? What I mean more, though, is that, for example, in your will, you have to name a personal representative, right? Don't just name a personal representative and not actually discuss this with that person, right? Or persons, letting them know this is what you're planning on doing and if they are willing to serve in that role, right? Same with a corporate personal representative as well. Some corporate personal representatives, corporate banks, corporate trustees, even for that matter, will reject the appointment because maybe there's not enough assets or for whatever reason. So you want to make sure to always have a discussion. Also, think about, even if they agree to do it now, they may change their mind later, right? So that's another discussion to have. Also, in your ancillary documents, when you name your healthcare surrogate, when you name your people that you want to on your HIPAA release, right? People that you want to share your medical information with. Who is going to step in your shoes for your power of attorney, right? All of these people you need to have discussions with. The guardian for your children, right? And the successor guardians and whoever else you are thinking about naming in any of your documents. It's great to say, hey, would you like to grab a cup of coffee and talk about it, right? That way they're just not shocked when they get a phone call. And make sure that they're comfortable with the decision. For example, a healthcare surrogate. They may have to make a decision on the cuff, if you have a surgery or something and the doctor needs to have someone make a decision on what to do. They need to know and be ready for something like that, right? So you always want to have a discussion, a conversation, and make sure they're willing to serve in that role. All right. And also make sure you name more than one, right? I always suggest doing a hierarchy. So you have person number 1, then person number 2, person number 3. That way, if person number 1 has changed their mind or they're unable to or unwilling to, or they can't be reached, they have person number 2 to call, and so on and so forth. All right. So that's mistake number 5, not discussing your estate plan with any of your family members or friends or any of the people you name in your documents. All right. I'll be back again tomorrow with another video.